Awesome. Thank you again to our great sponsors. And at this time, I would like to introduce our speaker, Gov Hutchinson. Gov has been with California Association of REALTORS since 1985, and he manages its member legal services program in Los Angeles. So if some of you have called the legal hotline, you may have gotten to speak to Gov in person. He advises realtors through the hotline on all aspects of real estate law. He trains and supervises other hotline attorneys. Gov has written for California Real Estate Magazine, co-authored California Association of REALTORS continuing education courses, and is a master instructor for the education division of the California Association of REALTORS with certification from California Department of Real Estate. Please welcome Gov Hutchinson.
Sounds like I should have been here for breakfast, but okay, I'm good. Good to see you guys. It's always great to be here. It's great to be anywhere, actually, after 2.5 years of Zoom only. I'm glad to see you guys in person. I'm on the road this week. Yesterday, I was in Visalia and Porterville. The day before that, I was in, where was I? Antioch? I don't know. I'm all over the place. Good to see everybody. Things have happened to me, and I haven't seen you for 3 years, I think. So it's good to see you. 2 important things have happened to me. I need glasses now. And I got married. How do you like that? I held out for 64 years. I don't know if anybody else can beat that record right there. So that's pretty good. Anyway, so time to do the legal update. As you know, as she said, I'm in charge of the legal hotline, and this is my other job. I just travel around telling you what's new forms, new laws, and this is the best time of year to do it, obviously, because this is the year when all the new laws got passed, end of September, and we got forms coming out in December, and some forms came out in June, so I'll talk about all that stuff. If you have any questions, just ask anytime. You don't have to wait till the end. I'll be glad to do it. I think you have to wait till you get a microphone to do it, or you can just yell it out and I'll repeat it, okay? So you could ask about anything you want. I would say compared to some years, this is not a bad year for new laws. Actually, I think you'd prefer to just not have any new laws at all, right? Wouldn't that be nice? That would be good. Yes. Okay. Yes. I'm going to talk about that. Yeah, I'm going to talk about that. His question was about confirmation of acceptance, and actually I was going to address that particular issue itself. Okay, so like I said, the governor signed 997 laws, but how many are relevant to real estate? Maybe 25. And we have a handout on our website called 2023 New Laws Affecting Realtors. And I'm only going to talk about 10 of them because they're really not that significant, which I think is good. You got to realize, and I think you've probably been told, that a lot of CAR's efforts in the legislative arena, most of CAR's efforts are opposing bad things. In other words, a lot of laws get proposed each year that we don't like, and we try to fight them. And we had a very successful year. All sorts of bad laws for realtors or property ownership got proposed this year. Did you hear about that one that was going to have if you bought a house and sold it within 3 years and you weren't living there, you'd have to pay a 25% tax on any profit? Crazy. Or there was a law that said if you sold a house with a tenant there, you'd have to first offer it to the tenant before you could sell it to someone else. And there's like a 2-month process it would take before you could do it. There were all these bad landlord-tenant laws, extending rent control, limiting the Ellis Act, a mandatory statewide rental registry, a law that would have said anytime a property became vacant, a landlord would have to pay for an energy efficiency audit. If you rejected a tenant based on criminal record, there was this extensive questionnaire you would have to fill out, all sorts of bad things, and they didn't get passed. And in large part to the efforts of CAR and you. So when you get an email that says red alert, call your assembly person, call them. They hate that when it happens. Oh God, the realtors are calling, and and they often do what we want. So, and also when you're asked to make contributions politically, every little bit helps, because the more money we have, the more people we can bribe, contribute to get them to vote the way we want. Okay, so keep in mind. So anyway, some laws were, first of all, before I get to the new laws, just big picture things. The two things I've been talking about more than anything else on Zoom the last 2 years were COVID rules and eviction rules. The COVID rules are over, and the eviction rules are finally over. In other words, statewide, there are no restrictions on eviction at all. Now, I'm from LA County. There are still local restrictions. I'm assuming Bakersfield doesn't have any local eviction restrictions, or Kern County or anything like that. So you're back to pre-pandemic rules on evictions and rentals, which is good. There are still issues you got to think about rent increases, because that's a common question I get. How much can I increase my tenant's rent? And I'll say, well, there are three things we got to think about. Number one, are you subject to a local rent control law? I think the answer here is no. But then the next question is, are you subject to California rent control law? You might remember it was right before the pandemic. All we were talking about was this new California rent control law. And then the pandemic happened, we stopped talking about it, but it's still there. Remember, if your rental property is three or more units and it's 15 years old or older, you're under California rent control, and you're limited by how much you can increase the rent. The limit this year is 10% statewide. So you can't increase the rent by more than 10%. Single family homes exempt, owner occupied duplexes exempt, buildings newer than 15 years exempt. Okay, on those properties, how much can I increase the rent? Is it unlimited? There's always this rule called the California anti-rent gouging laws, which says if your property is in or affected by a state of emergency, then you can only increase the rent by 10%. So how do I know if my property is in or affected by a state of emergency? Well, there's actually a website, Office of Emergency Services.ca.gov, which has maps of the whole state. You would know better than I if there's anywhere in Kern County that has any type of state of emergency, usually fire related. If you're in a state of emergency area, you can only raise the rent 10%. But the law also says if you're affected by, so the entire LA County is currently under a state of emergency. You're right next to LA County. And they can say, well, sometimes the neighboring county is also impacted, because the whole idea of the state of emergency is there's this fire, whatever, which caused people to have to move. And so you don't want to take advantage of that by increasing the rents. Okay, so does that mean that this county is affected by that? You never know. Plus, to totally complicate your life, we're still under a statewide COVID-related state of emergency until February. So does the COVID state of emergency trigger the California anti-rent gouging laws? We don't know. Here's what I want. I want one of you to test it. I want one of you to increase your tenant's rent by more than 10%. See if they sue you, and then tell us what happens. So, we'll see how the courts respond. In all seriousness, I'm always conservative when it's not clear. So, you know what my conservative advice to all landlords in California is right now? Don't increase the rent by more than 10% until February. Then you're safe. Okay. So that's an issue that comes up. Anything else to talk about rentals? Not really. Another big picture thing before I go on to the new laws is there's an issue that's happening about your websites. California, the federal circuit court that covers California has ruled that real estate websites come under the rule that websites have to comply with the Americans with Disabilities Act and be accessible to visually impaired people. Your common sense reaction is a website is a visual thing. If you can't see, you probably can't appreciate the website. But visually impaired people can have these devices, these screen readers, which if the website has the proper software, it'll interact with the software and they'll actually point it at the screen and get a verbal readout of the words on your website. The point is your website has to have that software. So on our website, your website, car.org, on the risk management section, we have about 40 or 45 one-page quick guides. One of our quick guides is called Website Accessibility and ADA Compliance. What I recommend you do is you contact your website provider and say, is the website you set up for me compatible, have the recommended software? Hopefully they'll say yes. If they say, I don't know what you're talking about, that might be a problem. And then you're going to quote to them on this thing. Well, you need to have this feature and you can probably work it out. But what's happening is there are plaintiffs out there that are just trolling websites. They're going website to website to website. And if they come to a website that they think is not proper, they send out a letter. And usually the letter says something like, pay us 10 grand and we'll leave you alone. It doesn't even say fix the website. It just says, it's like extortion. If you get one of these letters, send it to us, send it to CAR. CAR is coordinating a response and how to respond to these, because some of them are totally not legitimate at all, but some of them are legitimate. So bigger story is make sure your website is compatible has the proper software so a visually impaired person with a screen reader can access it. Okay. All right. That's a big picture thing. Let's now talk about new laws. Like I said, there aren't that many to talk about, and pretty much all the bad ones didn't pass, which is all good. But there are a couple of things to talk about. And then I'll talk about the forms. One law I actually like. I mean, by the way, like I said, on our website, car.org, just in the search legal Q&As, you can pull up something called 2023 new laws. It summarizes what I'm saying. One law I like. Have you ever noticed that sometimes you're in the middle of an escrow and the law changes and you're wondering, do I got to do this new thing? Do I got to give them this new form that just kicked in? When I opened escrow, that law wasn't even required, but now it's required. Does it affect this transaction? We never knew the answer. So the conservative advice was, yeah, you better do it. Like when the fire hardening form came out last year in the middle of your deal, you got to do it. Good news. New law says whatever laws are in effect when you open escrow are the laws you comply with during that escrow. You don't have to worry about doing something new that just got passed. So I like that. DRE stuff. One thing to remember is you all, starting next year, January 1st, 2023, if you renew your real estate license, you're going to have to take a new class on implicit bias. Also, the survey class is going to be changed and the fair housing class are going to be changed. It's not going to add to the number of hours you have to take, but it's going to be slightly different. CAR has gotten approval for our versions of these classes, so they'll still be free for you. So just notice it's going to be coming. Okay. Another interesting thing on DRE stuff is slight change effective next year. Let's say you want to get a broker's license. What are the prerequisites to get a broker's license? Well, number one, other than passing the test. Well, you either have to have 2 years experience as a salesperson or college degree, major or minor in real estate, or a law degree like I have. New law says if you want to use the 2 years experience as a salesperson, those 2 years have to be within the last 5 years. So if someone was an agent for many years, 10 years ago, they dropped their license. Now they want to get back in the business. Oh, I can be a broker this time. Now you got to be a salesperson again for 2 years if those 2 years weren't in the last 5 years. Okay. No big deal, I don't think. But that's something you should think about. One more thing about DRE. DRE periodically comes out with a bulletin, and they put things in the bulletin telling you to do something. And when they put something in a bulletin or put it in a speech, they usually mean, we're looking at you on this one. You better be careful. Latest things. Number one, they said, when a realtor is asked to recommend to a client a licensed contractor, you need to verify that the contractor really has a license and it's current and they have workers' comp before you make the referral. So cslb.ca.gov, Contractor State Licensing Board.ca.gov is the website to find out if the person you're recommending is actually licensed and has workers' comp. Yeah, I'll repeat the questions, by the way. You don't have to run around. Question is, what about Candyman? Yeah, because they're not licensed. So there's no license to, you're not saying they have a license. So there's nothing really to verify. And this doesn't seem to apply to home inspectors, seeing, termite, they just said licensed contractors. Another thing DRE is focusing on, as well as California Department of Fair Housing, is the fact that landlords, property managers, you need to know that you can no longer discriminate against tenants based on their source of income. I mean, in the good old days, if you had a vacancy for your rental and the applicant, let's say, was an attorney, you could say, I hate lawyers. I'm not renting to you. Solely because you're a lawyer. Yeah. Can't do that anymore. But more importantly, that means you can't refuse a tenant because they're a Section 8 tenant. Every landlord in California now is a Section 8 landlord. Yeah. I mean, that doesn't mean you have to take the applicant. You can still have standards, objective standards, credit score, eviction history, rent income, time on the job. And as long as you apply those criteria objectively and fairly, you can reject a tenant. And if that tenant happens to be Section 8, you're not rejecting them because they're Section 8. You're rejecting them because they didn't meet your objective criteria. But let's say you get only two applicants for your vacancy. One Section 8, one isn't. But the Section 8 one is actually more qualified than the other one in objective criteria. You better take the Section 8, because otherwise it's going to look like you rejected them solely because they were Section 8, which in the old days you were allowed to do. So the point is, there are testers now calling up landlords and property managers on the phone, pretending that they're real and saying things like, hey, do you take Section 8 tenants? When you get that phone call, say enthusiastically, absolutely, yes. We love Section 8. Send us more Section 8. We prefer Section 8. You don't have to go that far. But the point is, they're probably not even real. They're testers trying to see what your answer is, including DRE is doing this. So be aware of that. The other thing about DRE is, and you may have even heard me say something. I want to look, and we've checked with the DRE, and they're not as strong as they say. Anyway, in a speech, the commissioner said, realtors should be real careful about doing open houses for properties that's not listed with their office. Right? You got a friend at another company. I got an open house this weekend. Can you do it for me? You can. But the thing you got to keep in mind is you can only do license work for one broker at a time, the one you work for. Typically, when you're at an open house, you're probably engaging in licensed activity. You're probably talking to people about terms and stuff like that. So the point is, if you're the person, quote unquote, doing the open house, but it's not under your listing, you have to make it very clear to the people who are coming in that you are not with the listing office, you're not with the seller. You're there as sort of an independent potential buyer's agent. Don't let there be any confusion. And also making sure your E&O covers you for any problems that happen at an open house that's not your listing. So you just have to sort of make sure that maybe put up a sign or put something on your shirt saying, I don't work for these guys. I'm just here. I'm a realtor. I'm here to help. This is not my listing. Okay. Yeah. Yeah, her question is, what if what I'm doing is I'm sitting there at the open house, I've got a flyer, but the flyer I have isn't about this property, it's about me or something, right? Something like, I mean, that's what I'm talking about. Yeah, the DRE, we pushed back on the commissioner. We said, could you put something in writing clarifying this? They said, no, we don't go that far. So he's probably regretting that he ever said it. But he still said, we still think it's definitely best practice to do what I just said. So what you just said, you got a flyer, It does have the property on it, but it has the point. Just make it clear that you are not the listing office. Yes. Exactly. I mean, the argument would be it's the same thing as a showing. I mean, just because you're showing a house to a buyer, you're not the listing agent. But I think the thinking was the assumption that people have coming to the open house is that the agent who lets them in and gives them the cookies and stuff works for the seller. That's going to be their assumption. Whereas if you're just a buyer's agent showing buyer's property, I don't think they assume that you're affiliated with the seller. But maybe at an open house, they do assume that. Maybe that's the issue. I think so. I mean, that's never been spelled out. Her question is, so broker number one has the listing. Agent for broker number one has a friend in broker number two. Hey, can you do my open house? I think it's a good idea, personally, to make sure that broker is aware of that. Because the broker may say, no, I don't want any other agents doing, I want my brokers, you have your own policies. Brokers, you can have your rules for what your agents do, including this. So yeah, I would do that. I think that's a good idea. Good practice. Okay. Couple more new laws relating to rentals. Are there any new laws? Did you know that if you're a landlord, you have a vacancy and you have an applicant, you're limited on how much you can charge the tenant for a screening fee? The law was passed a few years ago, limiting that to $35, but adjusted by inflation. You know what it is this year? $52.46. You'd think they'd round it off. No, it's $52. Don't charge 47 cents, charge $52.46. And obviously inflation this year, next year, who knows what it'll be. The point is, this can add up for applicants trying to apply to a lot of places. In lieu of that, there's a new law that's going to create something called a reusable tenant screening report, where a tenant can get a verified, certified, affidavit signed tenant screening report that will be good for 30 days for multiple places they apply. Landlords aren't going to have to accept this. Landlords can say, no, that's great. I still want you to do their own, but I think they probably will, because it's going to be certified and verified by the agency that produced it. It'll have everything landlords want: credit score and eviction history, rental history, employment history. And the tenant's going to have to sign something saying, I swear nothing has changed in the last 30 days that I just, in other words, landlords aren't going to have to take it, but hopefully they will. I think it'll help out the process. Other second new law on landlord tenant, interesting, domestic violence. Kind of complicated. Point number one, did you know current law says, if you got a tenant who says, I'm in a situation here of domestic violence, I need you to let me out of this lease. Obviously, the tenant is saying the person I'm living with is committing domestic violence. I need to leave. You need to let me out of this lease. Current law says, landlord, you got to I'm going to make a big stepper, let her out. Okay. It's not all, it could be the other way around, but just for ease of talking, you got to let her out. The question is, what's the proof? Do you have to take the victim's word for it? Do they need to produce a police report, a temporary restraining order, a conviction, a criminal conviction? What's the standard? There's no standard. It's whatever the judge thinks is appropriate in this particular case when you try to do the eviction. But there's a new law coming out that says if a landlord doesn't allow the tenant to exercise their right to get out with a 14-day notice, the landlord can get fined $5,000. What's the moral of the story? Let her go. When in doubt, let her out of even if she's making up the whole thing. I doubt that they're making up the whole thing just to get out of the lease. So when in doubt, let her out. That rhymes. You're right. When in doubt, let her out. Okay. Another law, but this law goes further than that, says under current law, can the victim say to the landlord, I don't want to leave, but I need you to kick out the person I'm living with who's the perpetrator. Current law, the landlord doesn't have to do that. New law says yes. It's the victim says to the landlord, I want to stay. I want you to kick bad person out. Landlord has to do that. has to evict bad person and change the locks. Once again, what's the proof you're going to have to prove to the eviction judge? Not clear, not clear. But the law also says the judge can say to the tenant, all right, we're going to we're going to process the eviction, but victim, if you let the bad person back in, that's grounds for the landlord to evict you now. And if this bad person has demonstrated that they're not just a risk to the victim, they're a risk to other tenants. Sometimes the bad person starts threatening everybody. In that circumstance, the landlord can terminate the entire tenancy and kick the victim as well. Yes. Yeah, that's a great question. In other words, can the landlord say, well, the bad person who's leaving was the source of income. I need remaining tenant to requalify. No, you can't. Now, of course, if she can't pay the rent next month, they're going to evict her for non-payment of rent. In other words, she doesn't have the right to continue to stay there and not pay rent. So if she can somehow put together the money, you got to let her stay out the rest of the lease. No. Definitely, you don't have to do any. You have to help her in any way other than this. So obviously, you can tell by the way I'm talking about. There's this law is kind of vague and but it's a law. We got to deal with it. Okay, landlords have to deal with this situation. It's a new law that's coming out January 1st. Okay, all right. Enough on rentals. We have nothing else to say about rentals. HOAs, new law. HOAs, can a homeowner association refuse to allow the unit owners to rent out their property? Answer, they have to allow at least 25%. So you have a 100-unit HOA, and 24 people are currently renting it out, and you say, I want to rent out my property, they can't stop you because you're still under the 25% threshold. Once you hit 25%, if somebody else wants to rent it out, the HOA could say no more rentals, 25%. New law says, what about a partial? I just want to rent out a portion of my property, not the entire thing. I'm still going to live there. I'm just going to rent out a portion of it. Does that count towards the 25%? It does not. So you sort of have an unlimited right to rent out a portion of your property in an HOA. Remember, HOAs can still prohibit short-term rentals of 30 days. They could absolutely prohibit short-term rentals, Airbnb, et cetera, et cetera. A couple more laws. Tax law. Sort of good news in the area of Prop 19. Remember, Prop 19 is the one that says, if you're over 55, severely disabled, or the victim of a wildfire, you can transfer your property tax basis on your current property to a new property. You can sell the existing one, buy a new one within 2 years. You can even buy the new one first before you sell the old one. As long as both transactions happen within 2 years, you can transfer your low property tax base. Now, a couple of things were clarified last year. One of them is, you can do this even if the new house costs more than the old house. For example, you bought a house 40 years ago for $100,000. It's worth $800 now. You could sell it for $800, buy another one for $900. How much is your property tax basis going to be on your new $900,000 house? It's going to be the original 100 plus 100. The difference between the purchase price of the new and the sale price of the old. If the new one costs equal or less than the sale price of the old one, your property taxes aren't going to go up 1 cent. You can do this 3 times. You can move anywhere in California. A couple of things that were clarified is you don't have to be 55 when you do both transactions. You only have to be 55 when you do the second transaction. If you're a married couple, only one of the people has to be 55. So all you guys with your young trophy wives, you can do this. Or with your trophy husband. I don't know how it works. Whatever. Anyway, you know what I'm saying? I just got married. Yes. I don't have a trophy wife. She is approximately my age. So anyway, thanks for asking. Anyway, okay. That's not the new law, though. The new law says something interesting, which impacts people in LA County. And that is, let's say you're eligible for Prop 19. So you sell your original house, you buy the new one, You dutifully go to your assessor's office, you fill out the form asking the assessor to transfer the property tax, the low property tax from the old one to the new one. But they're backed up doing the applications. And now it's time of year now where they send out the bill. So they're going to send out a bill based on the purchase price, like 8 times more than it should be. New law says, taxpayer, if you filed the application and now you get a bill for too much, you can just ignore it. You can defer paying your property taxes until you get the proper bill based on your Prop 19 status. So this is going to give incentive to the county tax assessor's office to hurry up and process these applications, because they're not going to get any money from you until they do. In other words, up until now, you would have had to pay the bill and then apply for a refund once they did it. Okay, so that's good news, I think. Just a couple more things. Mobile home park managers are going to have to be certified. Going to actually have to take a test and pass a test, seeing if you know about the mobile home residency law, which is good. Maybe one more to mention. You know, we're living in an era of there's going to be water issues. You know, there's something I didn't even know myself. Did you know in California, current law says we're all only supposed to use 55 gallons of water per person per day inside? I'm not talking about outside, I'm talking about inside. And I bet you've never heard of anyone getting punished for going over that, because they haven't. Because the way the law works now is all of us are also within a local water district. And the local water district only has to make sure that on average, collectively, the average in the area is 55 gallons per person per day. So some people can go over, some can go under. If the average would hit above 55, then the water district would have to tell people you're using too much water. This doesn't happen. But the 55 number is going down to 47 in 2025. And in 2030, it's going down to 42. Shorter showers for everyone in the future. So get ready. Finally, there's a bunch of new laws, a couple of which CAR supported, which you don't need to know the details on. They're just on the general theme of making it easier to build housing. We have a housing shortage. We want to try to get rid of some of the red tape. There was one law we supported, which is going to streamline the process of converting commercial and rental properties, zones into residential. New process to streamline the whole process of building residential properties along major corridors defined as 4-lane highways and former strip malls and former parking lots. Property being built inside cities, infill areas, streamlined process getting permits. You don't know the details unless you're a builder or a developer. But they're important bills that CR did sponsor. There's also an interesting bill that says you own a house, you want to reconfigure the inside of your house to add more bedrooms. New law says no city or county can demand some type of hearing to approve that. We're not talking about adding space. We're talking about just converting the existing space, knocking down a wall or adding whatever you want to do. So if you want to add 1 or 2 bedrooms, you pretty much have the right to do it. More than 2, it could still be discretionary. Accessory dwelling units. Did you know in California, every one of us who owns a house or a condo has the right to build 2 accessory dwelling units? Number one, you can convert existing space, your garage, for example. As long as it's not bigger than 500 square feet, you can convert it into another unit, and you can build a separate accessory dwelling unit, and it's built by right. If you get a permit, you can do it. The cities can't stop you. The county can't stop you. The HOA can't stop you. They can, though, restrict. They can have setback requirements. They can restrict the size of the ADU to be 800 square feet, and they can restrict the height to be 16 feet. Starting next year, those height, first of all, they're saying setback requirements can't be so big that they, in essence, prohibit you from building the ADU. And second, the 16 feet is going up to 18 feet if you're within a half a mile of a transit stop, 20 feet if it's necessary to match the roof pitch of the ADU with the roof pitch of that main house. And if it's an attached ADU rather than a detached, 25 feet. Ooh, But unfortunately, they can still limit you to 800 square feet. So they're going to be thinner, taller ADUs, I guess, theoretically. So we'll see what happens. Finally, one more thing, last law to mention, I think, before I start talking about forms is REOs. A couple of issues with REOs. One of them is new law says if we're talking about a big mortgage servicer that does at least 175 foreclosures per year, and then they sell them off as REOs, big mortgage servicers will no longer be able to sell off their properties in bulk. They'll have to sell them one by one. This benefits individual homeowners because if they're going to sell them off as a bunch, who can afford that? You know, a big investor or something. But if they can only sell one at a time, that, you know, the individual person that can only afford one house has a better shot at getting it. Second, if it's an REO, all REOs, when they sell a property, when they put a property on the market for the first 30 days, they can only sell it to potential owner occupants. They can wait 30 days and sell it to investors, but if they want to get it off their books quickly, their only option during the first 30 days will be to sell it to an owner occupant. This is all trying to help owner occupancy, et cetera, et cetera, et cetera. All right, enough on laws. Let's talk about forms. And I'm going to get your question in a second. Okay. What forms came out last December? Just two forms. One of them was a new purchase contract. That was a big deal. And I'm sure you're totally understanding that form completely, so I don't need to talk about it, right? Do you know there's another form that came out with the new purchase contract that unfortunately we've noticed a lot of realtors haven't been using? It's called the TOPA, Tenant Occupancy Purchase Addendum. Here's the scenario. You're buying a house with a tenant already there. Obviously, as a buyer, you want to know, is that tenant leaving? If so, when are they leaving? Before close, at close, after close? And what if they're supposed to leave? I remove all my contingencies. I'm getting ready to close and the tenant is still there. Do I have the right to terminate the deal, get my money back, even though I've removed my contingencies? Or can I insist that the escrow closing be delayed until the tenant is out? Or am I just stuck with buying the house with the tenant there? The point is, you need to resolve these issues in the purchase contract. There is nowhere in the purchase contract to resolve those issues. So you need an addendum, TOPA, to address the issue of what happens to the tenant and what are the consequences if the tenant is still there. We've noticed a lot of realtors haven't been using the form. And then if there's a tenant issue that comes up, they don't know how to resolve it. There's no agreement on what happens next. This is just my pitch. When you're writing an offer on a tenant occupied property, use the TOPA. And I know what happens a lot of times. The seller says, oh, don't worry, that tenant will be gone. You don't want to trust that, right? You want to know what are the consequences if the tenant isn't gone. So TOPA okay, that was last December. Now let's talk about 4 months ago, last June, new forms that came out, 7 new forms, real quick. 2 are mandatory. One of them is, there's this new form came out to be given to tenants called Information on Dampness and Mold for California Renters. It's attached to the CAR lease form. If you use a CAR lease form by using that form, you're automatically giving this new required booklet to the tenant. Okay. And it only applies for 2022 tenancies. So if you have existing tenants, you don't have to worry about it. Even existing tenants who renew their lease this year, you don't have to do it. But if you have a brand new tenant, 2022, you got to give them this booklet. Well, now you're thinking, oh my goodness, I ran into someone a few months ago. I didn't use the CAR lease form. I wasn't aware of this new mold booklet, so I never gave them the new mold booklet. What is going to happen to me? You're going to jail. No, you're not going to. Just send them the form now. Better late than never. It doesn't need to be a hard copy. Just email it off as zip forms. Information on dampness and mold. Now you may be thinking, why in 2022 is there all of a sudden a mold booklet? You're going to not believe this. How many of you were realtors in 2001? Some of you, almost half of you. think back to that time, you might remember that was the year of the mold panic. Everybody talked about mold. Every association of realtors would have a mold seminar. CAR had a bunch of mold classes. Pretty much every buyer in escrow, as part of the due diligence, would engage a mold inspector. I'm telling you, almost every deal. The mold inspector would come out. He had this device. He'd measure the level of mold spores in the air. And he would tell you, you have 672 mold spores per million cubic, whatever. And then you'd ask the mold guy, is that bad or good? And he'd say, don't really know. You know, there's no real standard. So a law was passed in 2001 instructing the California Department of Public Health to do two things. Number one, come up with scientific standards as to how much mold in the air is a bad level. And number two, come out with an informational booklet for tenants. It took them 21 years. When this booklet came out last year, those of us on the hotline who've been there that long said, is this that thing they were supposed to do 21? Did it finally? Oh my goodness, did. But you know what? They still didn't do the scientific standards yet. That still had not happened. Do we even care anymore? Does anyone care about mold? Do your buyers ever get mold inspections? Sometimes. But how do they react to them? Oh, that's a bad number. You know, I don't know. The point is, that's a little background. Okay. So that's a form, though. It's mandatory. Give it to your tenants. Second and final mandatory new form, and this is worth mentioning, Fair Appraisal Act Addendum, FAAA. It is attached to the purchase contract. Did you know, you probably know this, you've been aware that when you pull up until June 21st, when you pulled up the purchase contract, you don't just get the RPA, you get 6 other forms: agency disclosure, potential dual agency, fair housing advisory, the wire fraud advisory, inspection advisory, and the privacy notice. None of those forms, by the way, had to get signed for your deal to be legit. And those are all forms designed to be given to the buyer. Listing agent already gave their seller, when they took the listing, the agency disclosure, the PRBS, and the privacy form. These are and the other 3 advisories, wire fraud, fair housing, and they also gave them the fair housing. And the other 2, the wire fraud advisory and the inspection advisory, are meant for the buyers anyway. So first of all, point number 1, you never need to get the seller to sign any of those 6 forms that were attached to the purchase contract. They're all designed for the buyer. And second, even if the buyer doesn't sign them, it doesn't invalidate your contract. The new form, FAAA, Fair Appraisal Act Addendum, it has the word addendum. When you see that word, that's telling you it needs to get signed by buyer and seller. If they don't sign it, you don't have a valid contract. What I mean by that is you have a contract, but either side can walk away from it up until the closing day. You don't want that. You want people to remove their contingencies and be committed. So all I'm saying is, unlike the other 6 attachments to the purchase contract, make sure this one is signed by the buyer and seller, not just the buyer, the seller. Okay? What if you close escrow and that form never got signed? Don't worry about it. Once you close, don't worry about all the things you didn't do. It closed, be happy. Okay. But this one, just make sure that it does get signed, because if you don't get it signed, you're vulnerable to the client walking away. Jeannie. It applies, believe it or not, even on a cash deal, because the cash buyer can get an appraisal. Which, by the way, what does this form actually say? It must be a pretty important form if it has to get signed. All the form says to your clients is, if you just got an appraisal and you think the appraiser was biased, here's where to file a complaint. It's not even a complaint form. It's here's where to get a complaint form. But it's a necessary form, so just do it. Yes. I can tell she doesn't like it. Go ahead. We can't stop every bad law. But the point is, all you got to do is give it to your client. It's just telling them, if you think your appraiser was biased, you can file a complaint. It doesn't mean you can challenge the appraisal. It doesn't mean you can challenge the contract or challenge the contingency. It just means you can complain about the appraiser. And it does happen, by the way. There have been documented cases where appraisers are discriminatory. By the way, bigger picture. Do you know what the difference is between an addendum and an amendment? We've always used those terms interchangeably, but ideally, you know what an addendum really is? Think of it as overflow. I don't have enough room on the offer to write what I want, so I'm going to add an addendum. I don't have enough room on my counteroffer to say what I really want, so I'm going to attach an addendum. Once you're in escrow with a binding contract and you want to change something you've already agreed to, that's an amendment. For years and years, and we actually have an amendment form now, AEA, Amendment of Existing Agreement. For many years, we didn't have this, so everybody used the addendum to change something that we've already agreed to. And you know what? You can still do that. But I'm saying, I think it's better to use the amendment form. You know why? Have you noticed that the amendment form has a 3-day expiration? So if I'm in escrow, I'm the buyer, and I want the seller to do me, cut this cost or do this, do whatever I want them to do, I can send an amendment in asking them, this is what the change I want. If the seller doesn't respond in 3 days, that's a no. Whereas if you submit an addendum, there's no time limit. Have this ever happened to you? You're in escrow, you submit an addendum and you get no response. Is that a yes? Is that a no? What's happening? And you're in limbo until they respond to you. Whereas if you use an amendment, at least after 3 days, you know the answer. Now, somebody may realize we've got some forms out there that seem like amendments, but they're called addendas, like the ETA, Extension of Time Addendum. You want to extend the time to remove your contingency, you typically use that form. Shouldn't that be called, really, based on what I'm saying, the Extension of Time Amendment? We're changing the name. We're going to change all the names of our forms that are called something addendum when they really are, based on my terminology, are amendments. So how do you like that? Okay. 5 more forms, none of which are mandatory, real quick. 2 of them deal with commercial. If any of you do commercial sales, there's now a commercial seller property questionnaire that goes along with the residential seller property questionnaire. Required form, no. Second, we have a new form coming out called the Mixed Use Purchase Addendum. You ever come across a property that's part residential, part commercial? Which form do I use to write an offer on that? You know what my answer has been for 30 years? You need 2 forms. You need a residential form and a commercial form. Finally, there's a mixed use purchase addendum. So you would just write the offer up on a residential and use the mixed use purchase addendum to cover the commercial part. So that's good. 3 more forms. Have you ever been dealing in a transaction where the other side gives you a form you've never seen before? It's not a CAR form. It's like their form, their office form, it's their own addendum, their own advisory, whatever. And they give it to you to give to your client. Now, the courts have made it clear that the standard of care for a realtor when it comes to forms is you need to understand the CAR forms. Or if there's a local Bakersfield addendum put out by the association, that's part of your standard of care too. But forms that come from like other people, like offices or Zillow form or whatever, it's not your standard of care. So what do? Well, by the way, some of you are thinking, but I don't even understand the CAR forms. But that's a different question. That's a different issue. That's a whole different issue. Okay. Anyway, the point is, you got one of these forms, you give it to we now have a new form, Use of Non-Standard Forms Advisory. So you'd give it to your client and say, this form here, they want you to sign. I have no idea what it is. I'm going to give you this form advising you to get independent advice to help you figure out this form. Of course, in reality, you can call the hotline I just got this form. What do you think? And you can probably email it to us and we'll probably talk to you about it. But the point is, at least we have a form where you can basically disclaim, say, I don't understand this form, which leads to another question. Other side gives you a form. Do you have to give it to your client? Yes. Does your client have to sign it? No. Unless it's mandatory by law, which it isn't. But then the other agent says, yeah, but my broker says they need to sign it and send it back, or I don't have a complete file and I won't get paid. And you say, that's not my problem. Now, maybe the other agent is someone you like, so you'll help them out and get your client to sign it. Maybe the other agent is someone you don't like. This is the opportunity you've been waiting for to stick it to them, right? But you do have to give it to your client. You can't ever hide something from a client. That's the surest way to get sued. Give it to them. Do I have to sign this? No, but they want me to give it to you, so I'm giving it to you. On the other hand, let's say they could make their form part of a counteroffer. They're saying, our counteroffer is you will sign the counteroffer and you will sign this attached addendum. So they're saying to your client, if you don't sign this company addendum, you don't buy the house. You don't get the house. In that case, they do have to sign it if they want the deal. And that's when you call the hotline. You tell them to talk to their own lawyer and say, maybe you want someone to read this form to make sure you're not giving up some rights. It's not, in other words, it's not your responsibility. But there is a new form called Use of Non-Standard Forms Advisory you can give them. 2 more forms. One of them is addressing this gentleman's question directly. He doesn't like the fact that the acknowledgement of receipt is no longer on the purchase contract, right? Okay. There's reason for this. Okay. I asked earlier who of you were realtors in 2001. I'm not going to make you raise your hand, but if you were a realtor before 1990, some of you weren't born in 1990, but if you were a realtor before 1990, you remember life before email. I vividly remember, I think it was 1989, when everybody all of a sudden got a computer and started sending emails. When I started at CAR in 85, in our offices, we didn't even have computers. That's how long ago. You young people can't believe this. There was life before email? Yes, there was. Back then, if you needed to deliver a document to the other side, an counteroffer, a disclosure, a contingency removal, whatever it was, you physically, get this, got in your car, drove to their office, gave it to them. Maybe you faxed it, but all that times you drove it over and you made them sign for it in your presence. There was no issue of whether they received the document. Email happened. We all got lazy. We all decided, I'll just attach the document to an email. I'll send it over, whatever it is, a contingency removal, disclosure, inspection, whatever it is, I'm going to send an email. You know what the problem with that is? Believe it or not, if I send you a document attached to an email, what if you say, I never got your email? What do I say? I mean, there may be technology out there where you can prove that someone opened your email, but not everybody has it. So there was always an issue. And the courts have never clarified what proof do you need to prove that someone received your email. So there's always been an issue. And occasionally it comes up where the other side says, I didn't get the form. I don't know what you're talking about. I never got it. Must have gone to my spam. I don't know. I never got it. You can't prove that I got it. That means you didn't deliver it. Which is why we had the acknowledgement of receipt, because we always have told you, I've been telling you for 30 years, when you send an email to the other side, make them acknowledge that they got it. Otherwise, they can say they didn't get it. Which is why on the purchase contract, all these years, right under the buyer's signature, there was a place for the buyer's agent to acknowledge receipt of the acceptance. And that was the standard practice. Buyer signs offer, seller signs acceptance, and you send it back to the buyer's agent and they acknowledge it. And then the listing agent knows we have a deal because I know they acknowledge that they received our acceptance. The reason that's not there anymore is, believe it or not, it's not necessary, because the fine print of the purchase contract now says, if you give me your email address and I send it to that address, I can, as long as I can prove that I sent it, I don't have to prove that you got it. The presumption is, in other words, the moment I press send, it is legally delivered. And what if you say it went to my spam? That's not my problem. You check your spam. Or I got it 3 a.m, I didn't notice it. I don't care. I can prove I sent it to the email address you gave me. Therefore, we all agree in this contract that is a legal delivery. Now, before I get to, there's a place on the purchase contract on the last page in the broker box where you put your broker's name, your DRA number, their number, and there's a line that says designated electronic delivery address. That's what I'm talking about. That's when you put your email address there. You're telling the other side, this is where to send stuff. And by the way, it doesn't have to be your regular email address. It could be your TC's email address. It could be any email address you pick. But the point is you're telling the other side, this is where to send stuff. So if you can prove you sent it there, you don't have to prove that I got it. So issue is some agents aren't filling that blank in. What does that mean? That means we're back to the old rules where they can play the game, I never got your email. Which is why we have a new form. Designated electronic delivery address amendment. In other words, let's say you're the listing agent and the buyer's agent submits the offer and they don't put in that designated address. But you don't want to have to do a counter offer just to deal with that. So your seller can accept the offer. And then you can send over this amendment. Hey, agent, you must have forgot to please give me your designated electronic delivery address. Of course, the other agent may have deliberately not filled it in because they like the old sneaky way, in which case you're going to deal with it. The point is we have an amendment for the sole purpose of adding a designated electronic delivery address. Yes.
Okay, that's great.
Okay. Okay.
Here's the actual thing I do going on. I write an offer and I ask the listing agent before I write the offer, how much time do you think you're going to get a response back? So we should give them 3 days, so we do the standard, for example, 3 days, 5 weeks. A couple things happen on the seller's side. Seller has an emergency where they weren't able to deal with things.
Oh, okay. Just go from where I am right now. Okay.
I'll repeat.
So let's say the seller, for example, had a family emergency come up. And even though their intention was to sign that, they just can't get to a computer. They can't do anything.
Right.
They get it back the next day.
Right.
They sign it the next day. The way the forms were, as long as I've been in the business up until this year, the buyer could confirm acceptance of a later date than what was in the designated deadline, and you can keep the deal in play. And that confirmation date and time would be the time that all the time frames would start. Now, as I understand it, if that happens, if that seller comes back the next day, the buyer has to start all over again?
No.
Is there an amendment that's going to change the deadlines?
Okay, great question. The question is, the purchase contract says now, it always has said, the presumption is you write an offer, you're going to say to the seller, how long is this offer good for? It defaults to 3 days. You can change that. But the question is, I'm sure this has happened to you. You've written an offer, 3 days to respond. Seller responds after 3 days, 4 days, 5 days, 7 days. They either accept or counter. So they're countering or accepting a dead offer. But the buyer still wants that. They still want it. And the courts have said, for that to be a valid contract, I mean, if the buyer writes an offer and the seller responds in 3 days, that's it. They've responded, they've accepted it, we're good. But if the seller doesn't respond, but they do respond, but in more than 3 days, the buyer now can decide whether they want to go forward or not. The buyer can say, you're too late, forget you. Or the buyer could say, even though you're late, I still want the house. And you're right. Courts have said buyers have to somehow communicate to the seller that they're okay with this being late. And you're right. If they just acknowledge the acceptance, that was one way to do it. So that way doesn't exist anymore. So I'm just telling people, just send them an email back. I got it. It was late. I'm okay with that. So yeah, there's another step. There's no form for that. I understand one of the benefits of that particular clause was to make that process easier, acknowledged. Don't blame me. I'm not the forms committee. Actually, overall, I still like the idea of this sending is delivering. But you're right. That issue, that makes that. I will, if you want me to. It obviously bugged you. I got it. So but I'll bring that up. All right. Last new form, and then I'll talk about the December forms. The seventh and final new form that came out in 4 months ago in June is a form you may never use. It's called, this is the year, as you know, fair housing, CAR apology, all this stuff going on. Along those lines, you know what a restrictive covenant is? I own a house. I can sell you my house. And if I feel like it, I can try to restrict who this property can be sold to or what you can do with the property. I could say, this property can never be sold to a San Francisco Giants fan. I'm sorry, you have to be a Dodger fan to buy this. I mean, theoretically, I could do that. I don't know how you'd prove that, but that would be legal. Giants fans are not a protected class. They're evil people is what they are. They're just kidding. I'm a Dodger fan. Anyway, the point is, or you can actually, you'll come across a deed restriction that says something like this property can never be used to sell or serve alcoholic beverages. Once again, no one's going to do that. And it'll be very hard to prove, but it'll be theoretically possible. Then again, you'll come across occasionally, unfortunately, an obviously illegal deed restriction that says, unfortunately, something like this property could only be sold to Caucasians. Those were legal. They have not been legal for a long time. But the issue is the property owner sometimes, it's not enough that it's illegal. They actually would like that deed restriction removed from the public record. So if someone pulls up their deed, they don't see that. And I don't blame them. That's offensive. The new law says anyone can go to the local county recorder's office, fill out a simple form, and pay no fee. And the recorder's office within 3 months has to redact that from the records. And each recorder's office has to initiate some process where they're going to painstakingly go through every single deed recorded in the county. If they find illegal restricted covenant, that'll take years. The more important one is we all now have the right to get an accelerated process. How does this affect realtors? The law says if you have a listing or sale on a property that has one of these probably illegal deed restrictions, you have to tell your client about this new process that they can take advantage of. Hence, we have a new form, disclosure to owner or buyer regarding restrictive covenants. But you know why I said you may never use that form? Because you only have to do this if you're aware of it. How would you be aware of it? You'd have to read the prelim and all the underlying documents, which is exactly what we tell you not to do. As a realtor, you shouldn't be doing that. It's outside of your required expertise. No need to get involved in that stuff. But I guess theoretically, your own client could discover it and say, hey, did you see this? And you're going to say, whoa, since you told me that, I got to give you this form telling you what you can do about it. See what I'm saying? All right. Okay. That's it for the June forms. By the way, before I do the December forms real quick, are there any forms that were changed 4 months ago? Not new forms, forms that were changed that you should know about, worth mentioning. Little things like the cancellation of contract form now has a checkbox. Have you ever had a client cancel the deal before the deposit ever went to escrow? Some people think if there's no deposit in escrow, there's no deal. So if I cancel, there's no consequences. That's not true. You have a contract. You signed a contract. Even if you didn't put your deposit in there, if you don't perform and you don't have the right to cancel, there could be financial consequences. At the very least, an escrow cancellation fee. So now there's a checkbox on the cancellation form. We're canceling before deposit has been made, and we understand that there might be financial repercussions, blah, blah, blah. Not a big deal. The request for repair form now has a box where the buyer can say to the seller, if you agree to do my repairs that I'm asking for, I'm removing all my contingencies. There's always been a box that says I'm removing my investigation contingency. Some sellers want you to remove all the contingencies as the price for them committing to do this work. So there's a way to do that. Little things. We now have one independent contractor agreement instead of two. Brokers and agents, you always have a contract between you called the independent contractor agreement. You may not have even known this, but there have been two versions. One had mandatory mediation if you have a dispute. One had mandatory arbitration. We now just have one form. It has mandatory mediation and mandatory arbitration. Mediation doesn't work, you go to arbitration. Just like the purchase contract, for example. All right. All right. The last form, I'm going to save it for the end. There were a couple changes to the fire hardening form, but everybody hates that form so much. I always save it for the end. So that's coming. Giving just a few more minutes now to talk about upcoming December things. Okay. Now, I'm not going to talk about all of them, and they're not done with them anyway. But I am going to talk about some things that I know are coming. And none of these at this point are mandatory or things you really have to do, but there's some good stuff. First of all, as a buyer on the purchase contract, you have 8 contingencies. One of them is if any part of the seller's property is not owned by the seller, solar panels, for example, they're attached to the property, which means they're a fixture. They come with the property, but they're not actually owned by the seller. They're leasing them. Seller has to disclose that, and the buyer has the right to review the lease. And if the buyer doesn't like the lease, they don't have to buy the house. That's a contingency. To supplement now, there's a new form coming out called Solar Advisory and Questionnaire. It's information about solar. It educates buyer about what solar panels are, what it means to own them, what it means to lease them, how you should deal with it as a buyer, what you might want to check out about. It's just information that's good, not required. I'd recommend it. You have a listing that has solar panels as an informational form to give to the buyer. Okay, good form. Buyer broker. There's a whole task force on this. Jeannie asked me, am I going to talk about it? I'm not going to talk about it. I don't want to talk about it. Here's what I'm going to mention. First of all, right now, there are 3 buyer brokers. Let me ask a question. I always ask this question. How many of you ever use buyer broker forms? We got like one guy, 2 guys, a man and a woman. Okay. They're not commonly used in California, which means you may not care about this at all. Right now, we have 3 versions of a buyer broker form. We have one that's exclusive, like it's like an exclusive listing. Buyer signs it, the buyer is committed to you. They're saying, if I buy anything in the next 90 days, I'll only use you. Second one, we have a non-exclusive one that says, buyer says, if I buy certain properties, or if I buy anything through you, I'll make sure you get at least 2 or 3% or whatever it is. And by the way, this doesn't mean the buyer has to come up with the money. It means if for some reason they don't get this amount of money through the MLS, the buyer will make up the difference typically. And then the third buyer broker form has no teeth in it at all. It's just, I'm your agent, you're my client. It's not exclusive. It doesn't commit them to pay you anything. It's just, putting in writing that the fact that you have a relationship. New form in December is simply going to combine those 3 into one. So you'll be able to check a box to say whether this is exclusive or non-exclusive or no compensation at all. So it's just combining those 3 theories into one form. I will tell you on the NAR level, on the Code of Ethics level, there might be a change that would say having a buyer broker contract is going to be a very definitive, almost definitive factor in any procuring cause dispute. What's a procuring cause dispute? Does this ever happen to you? Buyer number 1 I'm sorry, agent number one shows the buyer the property. Agent number two writes the offer. Which one gets paid? There's no rule like that. It depends. It depends on the fact, why did the buyer change agents? What happened? How much time passed? All sorts of factors have to be considered. One of the factors to be considered is, did either of these agents have a buyer-broker contract with the buyer? But that's only one of the factors now. It may become in the code of ethics that becomes a more important factor, like this should be weighed more than other factors. So in other words, maybe giving you incentive to get a buyer broker. This isn't in the process, hasn't happened, but I think that's going to happen. So that's just a tip. By the way, there was a proposal that didn't go forward that maybe all buyers agents should have to sign a buyer broker contract of some kind. That's not at this point going forward. Okay. But anyway, the point is there's a new form. It's just a consolidation of the 3 buyer broker forms. Third form, related to commission. Have you ever been representing a buyer who wants to buy a house that's not listed in the MLS, or it's not listed in your MLS or any MLS that you're reciprocal with? You still want to get paid though, right? So how do you get paid at a buyer's agent on a non-MLS listing? I think there are 3 possibilities. One of them is you go directly to the listing agent and say, you got a listing. I know it's not in the MLS, so I don't automatically get it, but I want you to pay me if I bring in a buyer. So I got this form called the CBC, Cooperating Broker Commission Agreement. It's a contract between me and you. You agree to pay me if my buyer buys the house. That's one way. Or of course, you might have a buyer broker contract where your buyer is saying, I'll pay you if you help me buy this house. But there's a third possibility. You can actually have the seller pay you directly. It's not like a one-party listing because you're not the listing agent. You're solely representing a buyer, but you want the seller to pay you. We have a form. Seller payment for buyer's broker. And there's actually going to be a checkbox on the purchase contract where you can check a box saying, see attached seller payment of brokers, seller payment for buyer's broker form. In other words, you don't really need like a type of commission agreement or something like that. This is basically in the purchase contract, you're going to attach something where the seller commits to pay the buyer's commission. It is, but nevertheless, it's a new form to get paid in that scenario. Okay. Now let me ask you another difficult question that I know how you're all going to answer. Do you voluntarily tell your buyer how much you're getting paid in the deal? Does anybody do that? Nobody does that. Of course, what if they ask you? You better tell them, right? And they're going to say, do you get paid for this? Don't say, oh, no, I'm free. No, never say that. That violates the code of ethics or the MLS rules. And probably if they ask you, how much are you getting paid for this deal? You should tell them. But there's no rule now that says you have to tell them or bring it up. This might change. It made the world, you've heard about these big nationwide lawsuits, Department of Justice, challenging the whole commission structure, saying buyers should pay their agent, sellers should pay their agent, none of this cooperation, blah, blah, blah. How is all this going to be resolved? I don't know. It'll take a while. Hopefully I'll be retired. But anyway, the point is it may become required though, either on the MLS level or legal level, that buyer's agents actually have to tell their clients, well, if you buy this house, this is how much I get paid. If you buy this house, I'll get this much. If you buy this house, I'll get this much. The point is, we have a form for this. Anticipated broker compensation disclosure. I want to tell you that when you see this form come out in December, it is not required yet. Maybe never. But maybe your MLS might require this at some point, or the law might require it, or you may just want to do it. You feel that you should do it. We have a new form it's a form where you can, as a buyer's agent, give to your buyer telling him about your compensation. Not mandatory, maybe never mandatory. Okay. So those are really the only forms I really want to talk about. There's a lot of our property management forms, our rent application form. I'd say a bunch of our property management related forms are all being tweaked. I don't have the details yet. I don't want to turn this into a property management seminar anyway, but look for that. The forms committee is still working. They may come up with something else, but that's the big picture of what's going on. Couple of small changes to the purchase contract. Have you noticed on the first page in paragraph 3 in the grid, talks about the buyer's loan, the loan buyer, they're trying to get a loan interest rate not to exceed blank, 0 points. Have you noticed it defaults to 0 points? In other words, the buyer is saying to the seller, my offer is contingent on getting that loan. If I don't qualify for that loan, I don't have to buy the house. And the pushback has been, well, that makes it too easy for the buyer to get out of it because almost all lenders require them to pay some points. So if they just always say 0 points and the seller goes along with that, or sellers aren't going along, sellers are countering and saying, no, that's too easy. I want you to commit that you're willing to pay at least 1 point or 2 points, whatever. So now it's going to say, instead of defaulting to 0 points, it's going to say buyer has to pay up to blank points. By the way, bigger picture on this, contingencies. There are 8 contingencies. Did you know if you want to cancel a deal based on a contingency, you have to act in good faith? You can't just say, well, I haven't removed my contingencies, I'm canceling. The seller has the right to say, which contingency are you using to cancel? The loan contingency. Oh, really? Does that mean you can tell me, you can prove to me you didn't qualify for that loan? Oh yeah, I did qualify for that loan, but it turns out I don't want that loan. Well, then you can't use the loan contingency. You can't use the appraisal contingency if it appraises. You can't use the HOA contingency if there's no HOA. You can't use the inspection contingency unless you tell the seller what it is you discovered about the property that you don't like. And maybe the seller says, I'll fix that problem, in which case you couldn't in good faith use the inspection contingency. Of course, the good thing about the investigation contingency is you have the right to investigate not just the property, but anything else that affects the property. So you can always come up with something, right? Well, I checked out the schools and I don't like the schools. The seller says, what are you talking about? These are the best schools in California. The buyer says, I know, my kids are dumb. I'll never survive those. What's the seller going to say to that? You understand my bigger point though. Okay. All right. The point is, that's a slight tweak. All right. Any other changes to the purchase contract? As I said, there's going to be a reference to that seller pay buyer broker form. Remember I said that a lot of people aren't using the TOPA form? We've realized some people may never use it, so now it defaults. If you don't use the TOPA, the seller is agreeing the tenants will be out at close. It's a presumption the tenant's going to be out. It still doesn't address the issue, though, of if the tenant is not out, what are the buyer's rights? You need the TOPA to deal with that. Okay, so I still say that. Anything else on the purchase contract worth mentioning? It's going to mention this solar form I just said. And that is really it. Oh, one more good thing. Have you noticed on the purchase contract, by the way, getting to his point again, you always need, even though there's no more acknowledgement of receipt, you always want to know what's the what day do we use as the 0 day to calculate deadlines, right? And the answer is it's the day the seller delivers the acceptance. And as I point out now, no longer does the buyer have to acknowledge that. It's the day the seller presses send. But you still want to probably acknowledge on the contract, everyone agrees what that day is, which is why on the last page of the purchase contract, under escrow holder acknowledgement, there is a blank there where everyone is saying, including escrow, we all agree this was the day of acceptance, and that's to start. But let me ask you this. All right, so you know the way deadlines work in the contract is the day of acceptance is day 0. And then if I have 17 days to do something, we count every day. But if the 17th day falls on a Saturday, Sunday, or legal holiday, the deadline is not that day, it's the next business day. So the question, which is a good question, is what's a legal holiday? Is Halloween a legal holiday? Is, St. Patrick's Day a legal holiday? Is Cesar Chavez Day a legal holiday? Is Juneteenth a legal holiday? And there was never a clear answer in the contract. Now, the contract refers you to Civil Code section, blah, 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 Civil Code section 7.1 and Government Code section 6700. Those list the legal holidays in California that this contract is referring to when it says deadline cannot fall on this day. Plus, a deadline the closing day cannot fall on a day where the escrow company is closed. Regardless of what kind of holiday it is, if the escrow company is closed that you're using, you can't close that day. Okay. Or the recorder's office, something like that. All right. Final thing I promised to talk about, by a couple of things. One other thing I want to mention. Okay, I can mention with this. The form, which in my experience traveling the state, that we get more questions on than any other right now is the fire hardening defensible space. Let me first ask a question. In Bakersfield, in Kern County, do you have any high or very high fire zones? In Kern County, not necessarily Bakersfield. All right. So this is relevant to you. Okay. Point number 1. If you have a listing in a high or very high fire zone, is this form required? Yes, assuming it's a TDS transaction. If it's a probate REO or bankruptcy sale, no TDS, no form, even if it's in high or very high. But if your listing is in a high or very high fire zone, this form is required. Okay. Some people ask me, I thought I should give the form to every buyer, but I only have to fill it out if it's in a high or very high fire zone. And I know why people thought that, because contrary to what I wanted, and I'm not on the forms committee, up until June, did you notice there was a paragraph on this form where the seller could check a box and say, this property is not in a high or very high fire zone, but I'm giving you the form anyway. I thought that was the dumbest thing. I'm so glad that's gone. So now my advice is, if your listing is in a high or very high fire zone, give them the form. If your listing is in a moderate zone or no zone, don't give them the form. Only give the form if you have to. All right. Because remember, every property in California is either in a very high fire hazard zone, a high, a moderate, or a nothing. If you're in the top 2 and a TDS is required, the form is required. All right, that's point number 1. So now your question as a listing agent is, well, how do I know whether my listing is in a high or very high? First step, go to the NHD report. Every listing you do in your entire life requires an NHD report. So my NHD report, on the signature page, it has 2 earthquake zones, 2 flood zones, 2 fire zones. One says very high fire zone, one says wildland area. If neither box is checked, you're not in a fire zone, don't use the form. If the very high box is checked, you're in a very high fire zone, the form is required. But what if the wildland area box is checked on the NHD report? What's that telling you? That's telling you you're either in a moderate fire zone or a high. And you're going to say, I need to know which one. You just got through telling me the form is required if I'm in a high, it's not required if I'm in a moderate. So the NHD report is only telling me I'm in one of those 2. I need to know which one it is. What do I do? Go to your NHD provider and say, thanks for telling me I'm in a wildland area. I want to know more. I want to know, am I in a high or a moderate? They should be able to tell you. They know, or they can find out. And some NHD companies I've run into have actually proactively added a checkbox to their form to do that. CAR is sponsoring legislation for next year that would require them to do that. But that is not in effect yet. And what if your NHD company doesn't have that box? Well, then you have to ask the provider, please tell me. What if they say, I don't know, or I'm not going to tell you? Point number one, think about getting a different NHD provider. Or alternatively, you, the listing agent, have to look at the map that is linked on the form, the CAL FIRE map of these zones, and you got to see if your property fits in the certain color zone. Obviously, ideally, you want the NHD company to give you that answer. So they're the ones who get in trouble for misreading the map, as opposed to you getting in trouble for misreading the map. Hopefully, this won't be an issue next year at some point, but you should all understand that. Okay, so let's say you've determined that your listing is in a high or very high fire zone. Now you got to fill out the form. There's paragraph 2, there's paragraph 3. Paragraph 2 is easy. Seller, 6 questions, yes or no. Do you have a wood roof? Do you have single pane windows? Do you have combustible landscaping within 5 feet of the house? Do you have non-metal gutter covers, etc.? Yes or no. What if the seller says, I don't know. I don't know what kind of gutter covers I have. You say, get a ladder, get your lazy butt up there and look. No, you don't say it. You say, you're allowed to say you don't know. Seller, believe it or not, the questions are all worded, are you aware? I simply don't know. Then check no. Now, just like on the TDS and the SPQ, have you noticed all the questions are you aware? They're not asking the seller, is it true? They're saying, are you aware? So I have no idea. Then check no. But don't skip the question. Big tip for you today. As a listing agent, don't let your seller skip any of the questions on the SPQ, the TDS, the lead paint form, or this form. Because if you don't answer a question, the form is not complete and the buyer still has their 5-day right of rescission. Did you know, even if let's say the seller fills out the SPQ, skips a couple questions, sends it to the buyer's agent gives it to the buyer signs it, sends it back. Buyer still has an unending right to cancel the contract because they signed and returned an incomplete disclosure form. I mean, obviously your best thing to do when you get that is send it back to the seller and say, answer all the questions. But if you're a sneaky buyer's agent, as all of you are potentially, you don't tell the seller that you noticed that they didn't answer all the questions. You just have your buyer sign it and return it, knowing you've got an ace in the pocket there. If your buyer ever wants to get out of the deal, they can just say to the seller, I'm canceling, give me back my money. Seller says, oh, no, you can't cancel. You removed all your contingencies. I gave you the disclosures. You returned them. You're right. I returned an incomplete disclosure. I still have my right to cancel, and the courts agree with that. So just think about that. So that's a general point on all the disclosures. Don't skip a question. Yeah. When you say old, it means the seller filled it out 3 months ago or 6 months ago. I mean, the old version of the form, not that the seller filled it out 20 years ago. Okay, I got it. That makes sense. No, you need the updated version. I mean, that's a very good question. Let's say they give you the non-updated version. Now, the SPQ is interesting. If you told me they gave you the non-updated version of the TDS, I would say that's an incomplete disclosure. The SPQ is partially required by law, partially not. So if the version that they gave you, the first 10 questions are the same 10 questions as today, it's still a valid form, even though it's not the updated version. But the rule about answering every question still applies. Okay? All right, almost done here. So we figured out whether we need the form, and it's very easy for the seller to answer the 6 questions. Yes or no, don't skip any. Which leads to the confusing part, which is defensible space. But it's not that confusing if you think about it. If you live in a high or very high fire zone, you're supposed to have 100 foot of defensible space. That's the law. It was the law last year, 2 years ago, 5 years ago, it'll be the law next year. So if you live in a high or very high fire zone, CAL FIRE or the local fire company can show up any day of the week, look at your backyard, say, those trees are too close together. You need to cut some branches down. We'll be back in 2 months. If they're still there, you're going to get fined. That's true today. That's always been true. This law doesn't change that. What this law says is when you're selling a house, either the buyer or the seller has to proactively promise that they're actually going to reach out to the fire company to arrange an inspection so that you can get documentary proof that you're in compliance. Okay. I will guarantee you that in Kern County, it's never the seller responsibility. In fact, there is no place in Southern California where it's the seller responsibility. In the city of Truckee, yes. The city of Paradise, yes. In a few other towns in Northern California, they have passed laws there that say, seller, you can't sell a house here until you go get an inspection. CAL FIRE, unfortunately, and some local fire companies have taken the position that that's true statewide. We have convinced the CAL FIRE leadership that that's not true. Yesterday, I was in Visalia. Apparently, the local CAL FIRE person there is telling homeowners in Visalia, you can't sell a house here if you're in a very high fire zone without doing a defensible space inspection. That's wrong information. Now I've got to call up that local CAL FIRE guy and tell him he's wrong. So if anyone around here tries to tell you that seller, you can't sell this house until you do a defensible space inspection, it's just wrong. Having said that, so now how do I fill out paragraph 3? There's one more wrinkle in this. So I've just guaranteed you there's no city in Kern County that requires this. But let me ask you a question. Do you know if there's any places in Kern County where there's a city that has passed a supplement to the state rule? For example, I was in Tulare County yesterday, and there are some places in Tulare County where the local communities have passed a law that says in this city, it's not just 100 foot of defensible space, you have to have 125 feet. Or in this city, it's not that the grass can be no longer than 4 inches, it can be no longer than 3 inches. In other words, cities have the right to supplement the state 100-foot rule. Unfortunately, when you're filling out this form, the seller is supposed to know that. They need to know if there is or is not a local ordinance, simply so you can tell the buyer that there is one. Does anyone know if Bakersfield has one? You'd probably know by now if there was. I'm suspecting there isn't one. Having said that, when you come to paragraph 3 of this form, 3A asks the seller to say property is or is not subject to a local vegetation management ordinance. I think you're all going to check is not, because you guys would know by now if Bakersfield had a special rule. Plus, I think you just told me that there probably aren't any very higher fire zones even in, so obviously they don't. So when you guys sell outside of Kern County in a place where you are in a higher, very high fire zone, you might want to check with the local city by calling up the city or calling up the fire company and say, is there a local vegetation management rule here? If so, you're going to check is. In Bakersfield, you're always going to check is not. Okay? Second question, once again, but obviously in Bakersfield, you're probably not even using this form. Because, right, Bakersfield has no very high or high fire zones as far as you know. All right. So then forget what I just said. That was confusing. If you're not in Bakersfield, don't even worry about this form. And since you guys are all Bakersfield, why am I even talking about this? Because some of you might work outside Bakersfield. That's why. Kern County. All right. The other one, seller representation. Seller is supposed to say, I'm in compliance, I'm not in compliance, or I don't know. Always answer, I don't know. And the third one is, don't check any of the boxes where the seller is promising to do something. Let it default to the buyer. And it says buyer within 12 months after close is going to reach out and try to get an inspection. But even think about that for a second. Is Cal Fire, the local fire companies, going to keep track of closed escrows? No, they're not. Are they going to say, hey, they closed 13 months ago. They never called us up to do a inspection. Let's go get them. I talked to Cal Fire and said, you can do that. They said, no. And they said, even if we do, and we go, we're not going to punish them for delay. We're just going to do the defensible space inspection. If they're not in compliance, we're going to make them fix it. But they could do that anyway. You know what I'm really saying? This form, who cares? But what I'm really saying is it's a required form if your listing is in a high or very high. And I hope I've explained how to fill it out right. Okay. All right. My final tips, doing a lot of risk management, talking and training with people, talking to risk management experts, and everything I say is sort of risk management. But, you know, we all agree on a fundamental principle that I've gleaned from 37 years on the legal hotline of hearing about complaints, hearing about lawsuits. There are two rules I can say to help you to avoid lawsuits. Number one, when you provide information to your clients, always say where you got it from and you didn't verify it. Attribute and disclaim. The square footage is 2,650 feet according to, and I didn't measure it. The ADU is permitted according to the seller, I didn't verify. So when you provide information to a buyer to protect yourself, as long as you say the source and you didn't personally verify it, you're good. And the second bigger theme, and then I'm done, is the biggest rule that I can say that's going to determine whether you get sued or not is if your client likes you, they're probably never going to sue you. If your client doesn't like you, you can make the smallest mistake and they may sue you. If they really like you, you can make a big mistake and they tend to let it go, believe it or not. So the next question is, what makes clients like realtors? And the most obvious one is responsiveness. When they call you up, call them back in 3 minutes. If you're that kind of agent, if they call you up at 3 a.m, call them back at 3:05. If you show that you're responsive and you're interested in what's going on with them, those deals, even if glitches happen, they tend not to result in lawsuits, which is a good thing to know. What if you have a client that it's not working out? You hate your client. Ever had one of those? Fire them before you even close. Just get out of that situation. Those are the ones that cause problems down the road. We even have a form for that. Fire your buyer. It's not called that. It's called cancellation of buyer representation. Listing agent, unfortunately, you can't just quit because you signed a contract. You can try to convince your seller to cancel it, but if they say, nope, you got to live out the terms of your listing here, well, then you have to do it. But if you're a buyer's agent, you don't sign a buyer broker contract, you can quit anytime. And too bad for them if they don't like it. Okay. Any last questions?
Question I have is because we get so many different responses.
Okay.
If you don't see something in a room, you walk in a room and nothing's in there that you notice.
Yeah.
Is writing nothing noted okay?
Yeah. I mean, that's just a strategy issue. I mean, you only have to disclose what is worth disclosing. So the avid is helpful because it reminds you to check every room. And the question is, I come to a room, there's nothing to disclose. There's no material issue in this room. Do I leave it blank? Or is it better to say nothing noted? Honestly, I don't think it matters. If I had to go one way or the other, I'd say nothing noted is probably better than blank. I will say this, another tip. God forbid you're ever in a trial lawsuit, it'll 9 times out of 10 be a disclosure case. And the avid will be up on the screen in the jury room, in the courtroom, that the jury is going to be staring at the avid. They're going to critique your handwriting, your grammar, but they're impressed the more detail you have. So it's always good to point, there's a 3/4 inch scratch 2 feet from the west wall. It's meaningless. It's not material. Strategically, God forbid you're ever in court, it'll help you. The more detail you want. I thought we already heard your pet peeve. You have another pet peeve. Okay. Pet peeve number 2.
Okay, my pet peeve when it comes to an avid is when I get an avid prepared by another agent that they hand wrote
Yes.
and I can't read it. My
Yeah.
client can't read it.
Right.
So this is just what I like doing. I always do this. I go out to the house and I take notes on an avid,
Right.
go back and I type it up on zip forms and send it out. Then there's no way anyone's going to be able to say we can't read this.
Good idea.
Thank you.
Great.
I think that's the last question.
Okay.
The last comment I'm going to make.
Behind you. There you go.
On the Avid, if you put nothing noted.
Right.
And it's sent off, and
Right.
then the buyer's agent calls and says, oh, did you notice the stain in the ceiling in the garage?
Right.
And you say, no, do you need to amend your Avid?
Okay. Good question. And I know why the buyer's agent might be asking this, because so the buyer's agent is saying to the listing agent, why didn't you note this? My reaction might be, well, buyer's agent, you note it. Why don't I need to go note it? Because the buyer's agent may actually know that, did you know this, that once the disclosures are given to the buyer, they have 5 days to cancel, but those are triggered by the delivery of the seller's TDS and the seller's Avid. The buyer's agent's Avid doesn't give the buyer any rights. So I always say to buyer's agents, do your Avid early, attach it to the seller so the buyer gets it all at once, so they have 5 days to cancel. So in the scenario where the seller fills out an Avid, listing agent does an Avid, seller does TDS act completely, and then the buyer's agent discovers something later, too bad for the buyer. They have no right to cancel. So maybe in this scenario, the buyer's agent is trying to get the seller to redo their Avid, because when you redo the Avid, that gives the buyer a new 5-day right. Now, if the buyer's agent discovers something that the listing agent was not aware of, seller listing agent has no obligation to redo the Avid. But maybe in your scenario, it's like the listing agent should have caught that. Maybe. If I'm a listing agent and it's something like a stain that I should have mentioned, maybe to protect me, I will do a new Avid, even though it's going to give the buyer a new 5-day right of rescission. But there's another twist on this. Let's say it's a big stain on the ceiling. Did you know you really don't have to disclose things that are completely obvious? What's the buyer going to say? I didn't see it. You know, buyers have an obligation to look at the house themselves. What you're supposed to be disclosing are things that the average buyer doesn't notice, but you notice because you're a realtor and you've looked at 67,000 houses in your life, and you know when something doesn't look right. Whereas buyers have only looked at 2 houses in their life. They have no idea if that looks right. But if it's a big, obvious stain on the ceiling, believe it or not, I would always write it in, by the way. But technically, you always have the defense if the buyer complains about it, says, you didn't see it? You honestly telling you didn't see that 3-foot stain on the ceiling? So there's all these issues. It's not a black and white answer. Yeah. Did you still have a question, or you were raising your hand for her? Okay. Believe it or not, I was wondering if anyone's going to catch me saying that. I personally, you definitely don't have an obligation to look at the prelim. And I always tend to say, if you don't have an obligation to do it, why do it? Only because, let's say you do it. What are you going to do with that information? You're going to tell it to your buyer, then they're going to ask you to explain it. Now you've started the ball rolling. Now you have to follow up, and the buyer's going to say, really, it says that? What does that mean? Blah, blah, blah. It's better if the buyer reads the prelim, and if they have questions, they come to you. If it's a simple thing, you could talk to them, but otherwise you say, good question, you need to talk to the title person. That's what it says right in the contract. If you have any questions, go to title. So I don't honestly think you should affirm it to, just like CC&Rs. It's not your job to read the CC&Rs. But having said that, law is always complicated. If you're the buyer's agent, not the listing agent, you're the buyer's agent, and your buyer says to you something like, hey, I'm really concerned about rules on pets. I'm really concerned about HOA restrictions on building. Then you're going to say, let's me and you look at the CCNRs. Let's just see if there's anything relevant, because the buyer has educated you that this is an issue for them. Did you know we have this form called buyer material issues? I always recommend you give that to the buyer and say, if there's anything that's really important to you, tell me. Because there was a court case, more than one, that said where the buyer successfully sued their agent saying, you knew this was important to me. You knew this pet issue was important to me. Why didn't you follow up on this issue? So if you give the buyer material issues form, asking them to tell you what's important, and they don't write that down, you always can say, I gave you the form. Why didn't you tell me on the form that that was important to you? Bigger picture is buyer's agents are not the same thing as listing agent. You have a heightened duty to your buyer if they alert you that something is particularly important to them. I think she was next, then her. Yeah.
Never provided the AVID.
Okay. Listing agent has an obligation to do a visual inspection and disclose in writing what they see. They are not required to do the AVID. They could write that on a blank piece of paper. They could write it on, try to squeeze it onto the TDS. We recommend the AVID because it helps the agent. It has great disclaimer language. It reminds you to check every room. But as long as the listing agent signs the TDS, the fact that they didn't do an AVID is okay. But what if they sign the TDS and check the box, see attached AVID? Well, then the disclosure is not complete until they do the AVID, which would be really dumb of the listing agent because they're just extending the buyer's right of rescission by delaying the AVID.
Okay, so in the case of the HOA, the pet, for example, wouldn't it just be best if you just gave them the phone number of the HOA and say,
Always,
yeah,
always. Best advice. Send them to the HOA.
Gov, there was also a question on
yeah.
Zoom. One of the questions was if how would the landlord say in regards to the domestic violence case, what if the potential perpetrator disputes and says, I didn't?
Well, the point is this. I mean, in other words, is this the issue where the landlord wants to evict the perpetrator, right? So in other words, the victim is going to say to the landlord, kick out this bad guy I'm living with. The landlord's going to dutifully start an eviction. But the person who's trying to be evicted can now go to court and fight the unlawful detainer and argue at the unlawful detainer, this is wrong, I'm not doing this, there's no grounds to evict me. And the judge will decide. But as a landlord, you leave it for the judge to decide. You file the process. The defendant can always show up at the unlawful detainer and argue against it. But as the landlord, you're going to take the presumption that she's right. I'm going to do this. We'll let the court make the ultimate decision. When in doubt, go through with the process, though.
I have a question regarding deed restrictions.
Yeah.
Can the buyer remove any deed restrictions or anybody, or is it just illegal? Or
well, as I said, that new law there's one type of deed restriction where you now can get them removed.
But if a deed restriction says no dogs allowed on this property, or you cannot have horses on this property.
No, you'd have to, whoever put the restriction on there would have to agree to remove it.
Okay.
Yeah. Which could be hard.
So that was actually one of the other questions was the deed restriction was a charitable home.
Yeah.
Is that considered legal?
Yeah. In other words, it can be, this property can only be used for charitable purposes, blah, blah, blah. If you have any doubt in your mind, always call a lawyer to give you the advice.
What's the website again to refer the client with the contractor to see if he?
Okay, yeah. Remember I said DRE has said realtors should not be referring contractors without verifying the license. It's CSLB, Contractors State Licensing Board, CSLB.ca.gov.
I have a question going back to tenant screening for rentals. So if you use a property management company, so I'm the owner and I use a property management company to do the screening.
Right.
Is that going to be on them?
Yeah. Yeah. That's why you use a property management company. Okay. Yes, we got another one.
If you have a house that has conversion, garage conversion, can that be included as far as square foot?
Yeah, but I would always say that. Square footage, including garage conversion, is this according to the seller? I haven't measured it myself. So as long as you're spelling out. By the way, so what you're really asking, is there a law that says whether you count the garage conversion or not? There's no law either way. Some of you are probably saying, what is the official determination of square footage? There is no such thing. Anybody can have an opinion. The assessor, the architect, the builder, the seller, the agent, the appraiser, all have opinions. No one is right and no one is wrong. There's no such thing as official square footage. Always just say the source and you didn't verify it. That's the easiest way to get sued if you don't do that. You tell the buyer the square footage is this. They come back and say, I don't think it's that. I'm going to sue you. They probably win. But if you said, here's where I got that information, they can't sue you.
Hi, I'm gonna change the subject. One time I sent an offer to an agent and he called and say, hey, Jolie, I think we're gonna accept this offer, but instead of paying you 2.5, which it was advertised, I'm gonna pay you 1.5 because I show the property to that person, and I didn't know. So I talked to my client and he said, yeah, actually he did. They didn't have any type of contract.
So you were the buyer's agent or the seller's agent?
He was the listing agent and I was representing the buyer,
So the MLS offered you
the MLS
2.5.
offered 2.5, and then he said, you know what, I'm gonna pay only 1.5 because I show him the property.
Yeah, they don't have the option to do that.
I used to say, I didn't know.
It doesn't matter.
Yeah, but my client said, Yoli, he did. But when I told him that I had an IT number, he said, I don't want to waste my time with you. And he actually bought the property. And at that point, I felt like if I don't say yes to 1.5, he's not going to accept the offer because I don't have any contract yet. So I felt really bad. I feel like I didn't know what to do. So I want to get some advice from you.
Unfortunately, that's an age-old issue. And there's no great answer. I mean, obviously, you hope your buyer, I mean, that's actually an argument for the concept of buyers paying their agent directly. That issue would never happen because your buyer would pay you the 2.5 regardless of what the seller wants. And obviously they can't just change the offer of compensation, and through the MLS, of course, if the deal closes, they can't change. You're going to get your 2.5. But I know your issue is, what if the seller is actually going to not accept the offer for that sole reason? I have no great answer for you how to prevent that from happening. So if you actually think that's the case, and you might think 1.5 is better than nothing, and that seller's really not going to do this, and the buyer won't make up, maybe your buyer will make up the difference in this scenario. Who knows? Or the buyer asks for a discount on the price to reflect that or something like that. But theoretically, there's nothing you can do in that scenario.
Okay, so it's 11 o'clock, so we're going to wrap it up with this last question.
In considering the square footage of a garage included with the house,
Right.
is it considered livable space if it doesn't have AC and heating in the garage conversion?
Yeah. I mean, once again, the way you're going to deal with that is you're going to spell that out. You're going to say the square footage is this, but it's not all livable space. You know what I mean? There's no rules on this. There's no rules on what's livable space for purposes of including it into square footage. There's no rules. You got to make up your own rules. So you're just going to spell it out. You're going to say to the buyer, the square footage, including the garage conversion is this, but the garage conversion doesn't have this or this. As long as you provide the information, you're not going to get in trouble. Otherwise, there's no rules. Now, some MLSs may have, in the MLS itself, may have a rule on something, but I'm not talking about that. Thank you. You've been very patient. Good to see you all. See you next time.